circumstances there's any, I can't say it's unfavored, but if you look at the comments, there's no reason, in my opinion, to give it. He does retreat. There's no argument about that. But I don't think it's necessary to be given.
Judge, I believe that it is appropriate in large part because this was, that there is no duty to retreat was mentioned in opening, and I believe Attorney Trofsky referenced it in a cross-examination that the defendant had no duty to retreat. So I believe that there should be, that's been put out to the jury. There should be a fuller explanation of what that means, that they can decide and they can see if there was opportunity to retreat. We see the defendant has plenty of open space in which to retreat. He does so right after shooting Mr. Rosenbaum. And also,
Well, yeah, no, I'll say that. Everybody was scattering then, and that dramatically changes the situation.
if you look at the FBI video where he ran to, there was absolutely no one there before the shooting.
The FBI video does not pick everybody up. The Zanin video shows it clear as day. There's 100 people over there bashing on windows.
Yeah, the Zanin, I don't remember which it was. I think it was Zanin.
Zanin.
Video, to me, depicted a large number of people who were engaging in violent activity. Well, property violence, but it's still, they're using clubs and wrenches or whatever else to be doing destruction to those cars that are right in the area which would have been the path of flight for the accused. And I'm wrong about that?
Yes.
In the Zanin video, you hear the 5 gunshots. You hear the first gunshot, which is Mr. Zeminski, and there's kind of a flinch of the crowd. And then you hear the 4 shots that Kyle fired.
Yeah, let's have a look at it. I sure formed the impression when I looked at it that this is just to the south of the area where the shooting took place, and that there was a very large group of people in there who were intent on riotous activity.
I agree that in the southern portion of the lot there is. The defendant testified that his first instinct was to try and head north on Sheridan, that he could not because Mr. Rosenbaum was there. But as their testimony is that he was somehow trapped or blocked in these rather loosely parked cars. And you will see, I believe in the video, that the route the defendant takes after shooting Mr. Rosenbaum.
I don't want to hear about after, because after, that's a different situation entirely.
All right, well,
Watch the video. Let's watch the video. Sure, you can put the sound on if it's there.
So over here past the hospital.
Can you pause it, please? Or go back 2 seconds? The defendant runs here. There's no one in that area.
Wait for the gunshots. Which comes in a minute, 10 seconds approximately. Just let it play. The crowd's getting louder. And starting a car on fire.
my God.
It seems to me that there's quite a bit of flight from that otherwise congested area after the shots are fired. So prior to the shots being fired, there were quite a crowd there.
Judge, I don't believe there's a crowd where the defendant ended up retreating to, but
Ended up is after the shooting had occurred.
I understand. So my main reason for wanting this instruction, or our main reason, is that the defense has already stated that there is no duty to retreat. So they've already put that in evidence. I imagine they will argue it again in closings. So I believe the jury should properly be able to instruct on the law regarding retreat.
Did you want to respond?
Your Honor, he's arguing the instructions. I'll keep my mouth shut. I said he's arguing the instructions. I'll keep my mouth
You
shut.
saw the video, Judge? There's hundreds of people with weapons causing damage. What happens after doesn't matter because it happens after. And I'm trying to do this on the law, which is that it's unnecessary based on the fact that self-defense is going to be given. And the question is, was the use of force in the situation reasonable? That is contemplated by not giving 810. That's what the committee says.
My inclination is to give it, but if I find it's adequately covered in the other instructions, then I won't.
Okay.
All right, anything else?
Judge, I don't know if there's any jury instructions. Obviously, this case, anyone can pull up any video testimony of anyone testifying. I'm just wondering if the court feels it appropriate or allowable to play portions of testimony to the jury on closings.
You mean from media sources?
Yes.
Wants to play court TV.
Well, I'm not saying
Well-
we want to. I'm saying we should talk about it now before anyone tries.
Well, that's a good point. I don't want to specify one, Court TV has certainly, and I might add, has done a magnificent job in this trial, in staying out of my way and just keeping things going, I think. So I'm not saying you shouldn't follow that. You could use any source that is carrying it, except not one where they're commenting on it one way or another. Of course, no one would do that, at least not if you knew what was good for them. So unless there's some objection, I don't have any problem with that.
I don't think it's appropriate.
We're not seeking to do it. I just wanted it out there before someone tried to do it.
I'm happy to agree that we're not gonna do it.
Oh, okay, well, let's
I
do
just
that
didn't wanna be blindsided,
Let's
so.
do that. Okay, so there won't be anybody doing that. Now, but you bring up a good point. If the jury goes into deliberation and wants to look at some of this evidence, of course, one would read the law, I think nowadays, to say that any scrutiny by the jury should be presence of the court here in the courtroom. I very, very strongly disagree with that. I think that's antiquated. I think that that's based actually on a case I tried right here. Once again, I was there. State against Maurice Pucci Franklin. And I'm not going to go into my usual dissertation on that, but that led to, I think, the Anderson case about showing videos and things. The law actually developed around recorded statements of the accused as opposed to videos of the actual events. But I think the general rule now is supposed to be that we're supposed to do all this under judicial scrutiny, and they have to ask permission, and then we have to supervise. One of the things that I find most offensive is that we've got to scrutinize it to make sure they don't play it too many times, so they don't overemphasize some aspect of the evidence. I think that's what the cases say. And I think, how dare us, the founders of the Constitution, have juries because they don't trust the judges, and the judges have spent the last 225 years returning the compliment by always suspecting that the jurors are going to be up to no good. If this were a bench trial, and like this. I watched it. How many times have I watched that video now? And you know what? I could sit and I could watch it maybe 50 more times. And in fact, the famous Boston Marathon bomber was resolved because an agent from the FBI watched the video over and over and over and over again and finally realized what nobody else had caught, which was that Mr. Tsarnaev, who is now under death sentence, well, temporarily not. We don't know what the outcome will be in the Supreme Court, but that everybody else was looking one way and he was looking the other. And it took numerous times looking at the video to solve that crime. So for me to monitor how many times the jury looks at something, if we're a bench trial and I looked at it 100 times and I finally decided I better not look at it anymore because I might prejudice myself, I'd get reversed because that's an absurd thing to say. So I don't want to sit here and monitor how many times they look at something. I did that once when when it was an attempted murder case of a police officer, and the jurors came down and they're told they can't even discuss it with one another, but they can't resist, and so they're saying, oh, "Look at that," and then I send them upstairs and they're not looking at it again, and I think that's really frightening. So I think if they want to see the exhibits, we should give them the equipment to see it and let them do what they want with it. So that's what I think. Now let me hear from you.
Judge, I agree with you that that is antiquated. I think this is the ideal case where giving them access or setting them up somehow with the exhibits would be great. I saw this as a issue. I did ask people at the Department of Justice to look into it. Not a formal opinion. They indicated they believe it would be reversible error. I asked even if there was a stipulation and if the defendant agreed, and they thought it would still be reversible error under the current law, and also, and I'm not saying it would be ineffective, but they thought it would raise an ineffective assistance of counsel claim if there is a conviction. I do not want this case to be a test case on long-established law. I agree that the law is antiquated, and with the explosion of technology in the last couple decades, it needs to be changed, and perhaps we can do so legislatively. But as it stands now, the state feels that we should follow the procedures, as antiquated they may be.
Defense?
I don't want them having a free-for-all up in the deliberation room.
Okay. Well, I'm not going to cram it down on this case. One day, with a short trial,
One that you're willing to do twice.
yeah. This is crazy. It's just absurd. And I'm the one, I guess, who's the dinosaur on technology, but I certainly respect it more than our law does. We need to talk about the lesser included offense instructions, Mr. Rittenhouse. The effect of these, right now, the charges against you, which are stated in the amended information counts 1 through 6, the district attorney has to prove each of them beyond a reasonable doubt in order to obtain a conviction on that particular count. And there's something called lesser included offenses, and I'm sure your lawyers have discussed it with you, but I want to make sure that you understand it, and I'm required to do that. And if the district attorney is not able to establish your guilt on the charged offense beyond a reasonable doubt, then the jury is instructed that they must acquit you, find you not guilty. If a lesser included offense is presented to the jury, any of the ones we talked about, which are less serious crimes, carrying a lesser potential sentences, if I allow those, then the jury, if they are unable to agree that you're guilty of the charged offense, will have the opportunity to consider whether you're guilty of the less serious offense. and could return that as a verdict, as an alternative to instead returning a verdict of not guilty. So you were, by having a lesser included offense included, you're raising the risk of conviction, although you're avoiding the possibility that the jury will end up compromising on the more serious crime. And you're also decreasing the risk that you'll end up with a second trial because the jury is unable to agree. Any question about any of this so far?
No, Your Honor.
Okay, if the jury finds that none of the crimes charged in the sequence, charged or submitted, has been proved beyond a reasonable doubt, then they must acquit you, they must find you not guilty. And they cannot convict you of more than one crime on each count. Okay?
Yes, Your Honor.
Your lawyers have objected to some of the lesser included offenses and not others. They have, on some of them, they have agreed that they're appropriate. You don't have to join in that agreement if you don't want to, and you have the legal right to overrule them. And we'd have to talk more about it if you decided to do that, but you would have that legal right and say, no, I want to go to trial on just the charge offenses, all or nothing, and make the decision to force the district attorney to prove each case beyond a reasonable doubt. That would be your decision. Have you had enough time to talk with your lawyers about this?
I have.
Have you had enough time to think about what you're doing?
Yes, I have.
You think what you're doing is the best thing under all the circumstances?
Yes.
Has anybody threatened you or pressured you or forced you in any way?
No.
Has anybody promised you anything in exchange for this?
No, they haven't.
Is your mind clear today?
Yes.
Are you feeling all right?
Yes.
Have you ever been treated for a mental or emotional disorder? Well, let me ask you this. The more important question is there any reason for me to be concerned that you kind of a disability, mental or emotional, that would prevent you from being fully aware of what your options are and making a rational decision? Any reason I should be concerned about that?
No, Your Honor.
Okay. Any other question anybody wants asked on this?
His pause was, I believe, because he's in therapy. I don't think he has a mental illness or anything.
Okay.
As a result of this incident,
Okay.
he has PTSD.
Okay. And but that doesn't affect his judgment or reasoning power at all?
believe so.
No.
He's wagging his head no, okay. Anything else before I accept his decision on this?
No.
All right, so I'll accept the waiver and instruct accordingly along the lines that I've already indicated. Anything else today?
Judge, while you were doing the colloquy, I looked at my email. I got another screenshot of someone saying they know someone on the jury. I forwarded it along just for transparency reasons to the defense and to the court. Only one now.
Disappointed.
I didn't get it yet. Well, wait a minute. Oh yeah, here it is. All right. All right, thank you.